number 75, the people of the state of New York versus Rong He. Counsel?
Good afternoon, Your Honors. Paul Skip Glacier with Appellate Advocates for Mr. He. I would like to start with the Brady violation, but can I reserve 2 minutes for rebuttal?
You may.
Thank you. People failed to provide contact information for witnesses who were at the scene of the crime and who inculpated third parties. And this was a violation of Brady because they had an obligation to disclose the means for investigating.
So is it your position that if you disclose the identity of the witnesses, but you fail to disclose the phone numbers and addresses, that is always a Brady violation?
Generally speaking, yes. There would be exceptions, but that would be the general rule.
All right. And in terms of this particular case, did we ever actually get a definitive ruling from the Supreme Court as to whether this was discoverable?
Several times. The main thing was that Justice...
There seems to be a lot of back and forth in the record of basically, how to put this politely, passing the buck from one judge to another because they're in front of lots of different trial court judges.
Well, what was happening, Your Honor, is that defense counsel found himself before different judges and tried to get a better ruling each time. So he, in front of Judge Shillingford, he asked for this information, and the people said, no, we don't want to give it to them. We only want to give the witnesses the phone number of the defense counsel, and Judge Shillingford said that's appropriate. That was a ruling.
Okay, so that's your position, that's the ruling we're dealing with?
Well, that's the ruling we're dealing with, especially in light of...
So when we measure whether or not this is material, in terms of whether it was a Brady violation, the third prong, do we look at it based on the information that Judge Shillingford had in front of her when she made that ruling, or do we use a retrospective lens looking about what happened at the trial to figure out whether there was a reasonable possibility that there would have been a different result?
Well, with respect to whether there was error, you have to look at the trial. It's true. But whether it's material, I believe, has to do with what has been proffered. And we have a third-party possibility here of someone else who committed the crime. That's extremely material.
Let me ask that question just a little bit differently. It's a somewhat unusual situation for a Brady case here where you have the people going to, well, the judge gets involved, right? The judge makes a ruling on Brady. Usually what you would have is the people fail to disclose something. The question is it material? Is it Brady? Is it exculpatory? And then we go through the steps, right? So the fact that there was a judge's ruling here, does that affect the Brady analysis in any way?
I don't believe it does, Your Honor, because what the ruling did was to permit the people's position to remain. So that's the Brady problem. So in essence, it would be withholding but blessed by the trial judge. That's right. So the Brady violation has been approved. That's what it is.
And that's not reviewed on an abuse of discretion. It's viewed through the standard, as Judge Fine was saying, standard Brady lens.
That's right. That's what I believe. The people offered to contact the witnesses and give the phone numbers of the defense counsel. I believe what that did was to turn over the defense investigation to the witnesses. The witnesses then would have to decide they want to contact defense counsel. Why would the witness want to do that? And then actually do it in a timely fashion. That is not an adequate substitute for a defense investigation.
Are there any proffered suggestions by defense counsel as to if the prosecutor had some concern, and that was the reason why they suggested that they go through the court? Did defense counsel take a position on that?
Yes. First of all, he has offered something other courts have ruled on, which is a protective order preventing him from disclosing the information to his client. His client doesn't know the information, nobody's in danger. And if we can't trust the officer of the court to abide by a protective order, we have bigger problems than Brady. That was a perfectly reasonable alternative that would meet the people's problems with safety, which, by the way, there were none. There had been no indication of any threats made to anyone.
But that's one of the reasons why I asked you the question that I did, because I think maybe at the time the judge gave her blessing to this method, that hadn't been established, but perhaps later on there was.
I disagree. I don't think it ever was. The threats that were alleged came later, and they were against prosecution witnesses, not defense witnesses. These are defense witnesses who...
I want to focus, if we can, on what the record establishes on the materiality, because any materiality analysis has to be closely tied to the record. And if I understand your argument, you're saying that there was perhaps another perpetrator, there was two perpetrators, and that's what these two witnesses would have provided. But isn't there also evidence in the record that suggests that this was really ultimately tried as a not whodunit, but a what happened case, right? Those are the two typical scenarios in a criminal defense. And it was a self-defense or justification defense that was put forward. And so how does that square with your saying that it's material because it would have gone to identification?
Because the Brady violation foreclosed that defense. It prevented the defense from making the third-party culpability argument, and so he's left with a worse alternative.
But didn't he try to bring some of this out anyway through the examination of the police witnesses, through the statements and the DD-5s, et cetera?
He did his best, Your Honor, and the court told the jury you can't use this as evidence, only as impeachment. This was not...
There's also a problem that we don't know what interviewing those witnesses might have revealed about other potential witnesses.
That's exactly right. One of the things I was going to get to. Not only do we don't know whether the recantation by one of the witnesses would have been flipped because the jury heard that. We don't know what other witnesses that may have been turned up. This is classic Brady information that he couldn't get at it because the club was closed.
So it's not so much that it's exculpatory, but that it would lead to information that might
That's the standard. This court's
defense?
In Andre W., it's the right to the defendant to discover potentially material witnesses.
Was there ever a hearing held here like there was in Andre W.?
No.
No? You went through 4 judges, right? Shillingford, Judge Mangano, Judge Miller, and Judge Donnelly?
I think that's right. 3 of them ruled on it. Justice Miller said she's ruled, and Justice Donnelly said it was unambiguous, you lost. So there's no question about the ruling.
Were the court notes that Judge Shillingford had made, is that correct?
Yes, that's right.
I see. On the prejudice prong, which is the only prong that's relevant really here, subsequent, you didn't get the contact information, but subsequent to that, there's a trial, there's a confession, and there's video evidence of the defendant allegedly committing the crime. Doesn't that eliminate any prejudice?
No, Your Honor.
Why not?
First of all, there's false confession. Secondly, the confession did not match the medical evidence. The object that was claimed he used.
The confession was before the jury.
Yes, it was.
The statement that he made to police officers, right?
Right.
Yeah.
Right.
And isn't there you know the record better than me. I thought he identified himself on the videotape also.
He did as leaving the place after this melee. So I don't think you can go by the confession because it's not accurate. The witness identified the person after telling the police originally, I didn't see the face, and they closed the case.
And what do you think? It's not to. How are we to view this in light of the recent changes in the law?
Well,
Go ahead.
The changes of the law have been meant to strengthen Brady, not eviscerate it. And
they aren't directly relevant to this case, but it's a policy matter.
That's right. That's right. And the State Bar Association report that I talked about in the brief and the court's own press release indicates we take Brady seriously. How can this conduct be reconciled with that policy? I don't know.
Counsel, it's
Counsel,
a
you
little
want to
hard
take a moment on the Payton issue, please?
Sure, Your Honor. The main thing I'd like to say about that is that the police should not be permitted to conduct an unconstitutional procedure in order to justify an unconstitutional situation that they had created. That's what happened here. There was a Payton violation, and then in order to get probable cause, since they don't have it because it was a Payton violation, they do a suggestive show-up. This isn't the reverse. You can use a suggestive
What if there wasn't a Payton violation? I don't know if I agree with you. Our case law says if you're in the hallway, that's a Payton violation.
Your Honor.
It's hard for me to understand the expectation of privacy in that location.
Okay, part of the problem is the people didn't bring the right witnesses to that hearing. We don't know actually where he was arrested. We only know where he was seen when the other cops arrived.
Well, let me ask you this. If we reversed on Brady, just
Yes.
assume that for a second, doesn't the Payton issue get relitigated ab initio because of our decision in Garvin?
I suppose that's accurate, yes.
Wouldn't that
Really?
be-
Why, we would be remanding for a trial if there's a Brady violation? Would we be remanding for, you don't usually get a second bite on either side.
You know what, I take it back. I think
I'm
Your
sorry.
Honor is correct. I take that back. I think the hearing would stand, in which case I think you should address the...
So even if someone viewed Garvin as a change in the law that rendered the prior suppression decision incorrect, you'd be stuck with it?
I'm sorry, say that again?
Even if Garvin represents a change in the law
Yes.
as regards Payton, let's also just assume for the purpose of argument that everybody would agree that and you don't have to agree to this, but that everybody would agree that the suppression decision here is wrong under Payton after Garvin.
Respectfully, I don't think it matters because you don't have jurisdiction over this because of LaFontaine.
Well, that's the question.
Would it go to the flagrancy of the police misconduct under the Payton evaluation?
I think the Payton evaluation is a separate analysis from attenuation. Yes, the flagrancy of it becomes part of the attenuation analysis, but it is what it is once the Payton analysis has taken place. So they're not interrelated in that way.
And counsel, was there a witness who called 911 and alerted the police to his location? How does that factor in here?
Well, that part of why this isn't an intervening factor. All of that information that they got from the show-up was already known to the police at the time they did the arrest. So there wasn't anything new that intervened between the arrest and the statement. That's what Justice Hall dissented on.
But we've never held that the intervening circumstances as, a necessary prerequisite. I mean, there's a lot of factors that go into a factual finding of attenuation.
Well, that's true, but the other factors go our way. It wasn't too long a time.
Or hours.
But this court and other courts have held that that's not enough to attenuate. And in fact, that together with Miranda is not enough to attenuate. So we're
But all of
focused on the
these-
other ones.
All of these issues are mixed questions, are they not? All
Yes.
these individual,
Except for the fact that the
factors.
appellate division used the wrong legal standard when it was talking about the interrogation occurring at a different location with different interviewers. It has nothing to do with attenuation analysis.
Why wouldn't that go to the time frame and to the flagrancy? Maybe we've never actually said that in this context, but why wouldn't that be relevant?
Your Honor, no one has said that in this context, and I don't see how it would be relevant because what we're talking about is what has happened between the timing of the arrest and the timing of the statement, and there being a different location. It's almost always going to be a different location. It's going to be different.
But it's a break. It's a break. It's
But
it's not one continuous thing, and I think that's part of the analysis. And so,
Well, that's
have we
part
ever
of-
said that the factors that we've articulated were exclusive factors?
No, you haven't. But there isn't anything about those two factors that informs attenuation. The way it does inform whether there's a break in psychological questioning in the question first context, that's very relevant to that. It's not relevant to this because the break you're talking about is the time, not who's doing the investigating.
Let's assume that we agree with you on that. So even without that, how can we not say that there's record support for the determination that there
Well,
was attenuation.
the point is, under Borges, if there's an incorrect analysis that's taken place, then there's a question of law without preservation. So that's.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon. My name is Seth Lieberman. The people fulfilled their Brady obligation in this case by providing the defense attorney with the documents showing the witnesses' names and the information that they provided the police, by offering a reasonable alternative to what the defense had suggested, which was namely to contact the witnesses themselves.
Counsel, you'll correct me if I'm wrong, the ADA at the time, the prosecutor at the time said that was the policy, and so it wasn't unique to this case. Is that still the policy of this district attorney's office?
It is our policy to try to not give that information. That is correct.
So that's the first response. You don't give that information.
We have a legitimate concern about witness tampering. But in this
But
particular...
I'm saying that's the policy regardless of the actual facts related to any particular case.
In general, yes. I can't say that in every case that would be the policy, but in general.
But they were making a Brady claim here, right? I mean, they weren't saying these, I just want your witness list, and the answer to that is our policy is we don't give out our witness addresses. They were saying there's material in here that's Brady, and the office has an obligation to make meaningful Brady disclosure.
And they did.
But their answer to that was, well, we'll let them know you want to talk to them, and we'll see what they say, and we'll get back to you. The way I think about this case, I know you argue exculpatory nature of the materials, but what if this was a case where you had a report from John Smith, and John Smith says, it was there, I saw somebody else do this, gives a full description, and it is so completely exculpatory, and the answer of your office is the same one you gave here. Would you think that was sufficient?
Yes.
Oh, we'll let them know if you want to talk to them.
Yes, Your Honor. Let me just spell this out. We provided an alternative which may very well have...
It has to be meaningful.
And it was meaningful.
You gave the ability, we'll be the messenger, essentially. But there's no direct contact. And I'm not saying, I think Judge Feynman was getting to this earlier, should there be a rule that you have to give an address or you have to give... But shouldn't there be, particularly in this day and age, some meaningful way to make direct contact? That could be a blind email. That could, and I'm suggesting things.
Your Honor, there are many ways to have provided the defense with an opportunity to gain access to the witnesses, and by gaining access, meaning actually making contact with the witnesses. We provided an alternative. The defense never explained why that was inadequate. And, excuse me.
Well, the defense did make an alternative proposal that you rejected, which was that the court could make a protective order. So
Right.
what was wrong with
Well,
that?
that wasn't an alternative proposal with respect to how to actually get contact between the defense and the witnesses. That was just a protective order.
Well,
Protective order just goes to protecting the witnesses. But what we were offering was an alternative means of the defense obtaining access to the witnesses.
But that's my point. The defense wanted to make the contact directly to those potential Brady witnesses and said, if you give me the information to do that, I won't give that information to my client. Then all of your concerns about witness tampering and all that presumably would be resolved. So
Actually,
what was the
no,
problem with that?
because often the defense attorneys rely on investigators that in the past, a number of them have acted unscrupulously. So those are the...
Well, you could have made that part of the protective order, right? That the counsel could not share that information with anyone, correct?
I suppose, yes.
And if you had made that showing.
Yes, but we provided an alternative that stood some chance that the defense attorney would actually be able to contact the witnesses. He never took us up on that. And if he had, he might well have gotten access.
Well, because what Brady requires is that they have the kind of information that they can go and proceed with their investigation and to make the contact. It's not give me the information and then you go and contact the witness and let us know if perhaps the witness wants to talk to us.
Well, if that works, then it works.
Well, how would you
And if
fig-
it
how
doesn't
would-
work, if it does, can I just finish? Sure. Yeah, I'm sorry. If it didn't work, if in fact we'd come back and said, we spoke to the witnesses don't want to talk to you, then the defense could have said, okay, then we have to do it my way, because your way didn't work.
So
Didn't he-
what's the judge to, then what's the judge to do then? And then you go back to the judge and you say, Judge, we have a witness who doesn't want to talk to him at all. They're afraid of the defendant. If there's any contact here, we don't know. Maybe this witness will disappear and won't even be available for trial. And then, so you build up your case for not giving the information.
But there were other alternatives. We could have brought the witness to the district attorney's office. We could have subpoenaed the witness and brought them to the courthouse.
But how meaningful do you think it would be to have a rule the other way around, that you had to do your investigative work through defense counsel? Would that be adequate?
Well, it's not as if there's a rule. It's not as if it has to be done in one particular way, as long as it's a meaningful way of providing the defendants with an opportunity to gain access. We did that. The defense didn't choose to go that route, and if they had...
And then you didn't say, okay, so we'll bring the witness to the courthouse, exactly what you've suggested now, so you can have that interaction.
Wasn't that...
Did I miss that?
I'm sorry. Wasn't the defense supposed to say, I don't think that's your method is going to work because, and I'd like to suggest this method. But the defense never actually preserved why...
I don't know, Brady says you've got to turn it over. He says you haven't turned it over. You say, we don't want to turn it over. It's our policy, we never do. Okay, well, maybe we can do this for you. He says, that doesn't work. I want the information pursuant to Brady. You certainly could have come back and said, no, Brady doesn't require that. We're never going to do that. Or, oh, how about this one? Once he's made clear they're trying to have direct contact with the witnesses.
I go back to the fact that if he had used our route, he might very well have had contact with the witnesses.
Or he might have alienated the witnesses if, by some chance, the prosecutors go to these witnesses and they say, I don't want to talk to the defense. Now the prosecutor's going to go back and say, now you have to tell them yourself. And that can already be kind of, oh, now I have to do this and I have to. Whereas if they had contact themselves the first time, they could make their pitch as to why they should talk to the defense lawyer without having the first approach, which now may be kind of locked in, done by the prosecutors. Why isn't that a good reason just to say, no, that doesn't work?
Well, the defense didn't provide that as a reason in the first place, so that isn't preserved. And second, the defense attorney might have faced a situation where the witnesses were fearful of the defense, and if the people had come forward first and saying, the defense attorney wants to talk to you, that might have actually put the penumbra of the people's office around this request.
Counselor, this sounds rather speculative to me, and what I am having trouble understanding is why this doesn't run afoul of Andre W., that says that you have to have a founded fear for witness safety, not just a general policy that you're afraid of witness tampering. And every answer that I've heard you give here has all boiled back down to, hey, that's our policy. You get to try that first, and if that doesn't work, then we'll see what happens next.
Well, we're generally concerned because of past experience. This happened to be
my point is that that's not what we've said is permissible. So you seem to be trying to explain why that's a good policy, but we've said that doesn't work.
I'm not sure if this court has ever set a rule that it has to be done a particular way. And so long as the people provide a meaningful opportunity,
But
they do.
Brady is about disclosure, not about the prosecutor being a gatekeeper. Brady is pretty straightforward.
Okay, well, maybe I should move on to the materiality issue.
I think that's a good idea.
Okay, so in this particular case, there was absolutely overwhelming evidence of the defendant's guilt. The defendant made a statement inculpating himself. He lived 10 blocks away from the scene of the crime, and he was identified.
Without the statement, is there overwhelming evidence of guilt?
Well, we still have the ID where this particular witness, Tong, had an extraordinarily long opportunity to actually observe the defendant in the first place, and then made a lineup identification of the defendant and then an in-court identification. So there would be, but the statement certainly makes it overwhelming. And by contrast, the only materiality analysis
What if these witnesses were willing to come forward with exculpatory evidence, and the defense then changed its tactic and instead questioned the confession itself? Isn't that possible? I mean, here you have somebody who's speaking through an interpreter, and maybe would raise that it was an invalid confession, but chose a different tactic here because he didn't have that exculpatory.
Well, actually, he did make use of those reports. The content of those reports actually was before the jury, and he did make use of them as if it were exculpatory.
Yeah, but for what purpose? What was the jury instructed?
For two purposes.
Instruction? Yeah.
Well, he was permitted to suggest in summation that the accounts in those reports contradicted the witnesses' accounts. But putting that aside...
That's not evidence in summation. What was the instruction to the jury?
Well, the jury was instructed that it was to be considered as what was told to the police. But let me just continue with the materiality point, which is basically there was additional information about these witnesses, which was they ultimately said they did not observe the assault, and the most exculpatory material was from this person, Zhao, who said that he saw two people attack a victim with beer bottles. And that is totally, totally at odds with the actual injuries that...
The video and the medical evidence.
And the medical evidence, absolutely, totally at odds, because you can't... The medical expert explained that it was very unlikely that you get a shard of glass that would have been long enough to inflict such deep wounds. And what he neglected to mention, and this is common sense, the bottle is curved, and the wounds were straight. And if you slash somebody with a curved edge, that's not going to be a straight cut, that's going to be a mess. And that was not the nature of the wounds.
It seems to me, and we had recent cases on this, that the materiality analysis is always a very difficult thing to do in hindsight. It's just the nature of that test. One, I think this is the lighter standard, the lower standard, because it was specifically requested, but that's helpful. But it isn't so much, okay, we had the evidence at trial, and now we weigh that against these reports. That's a hard thing, because assuming this is exculpatory and it was withheld, they never got a chance to develop the record as to what those witnesses would actually say and how they would say it. So it's a difficult analysis to do, and I thought the Supreme Court was leaning more towards, does this shake confidence in the verdict?
Well, absolutely not.
Which goes to, of course, your point about the strength of your evidence, but the harder question, I think, particularly here, then, is how would this have fundamentally altered the defense theory of their case, perhaps from a self-defense to a misidentification and that, to me, is what the argument would be here in terms of the confidence one would have in this verdict.
This does not at all enhance a lack of confidence in the verdict, because you actually have additional information about the witnesses. I mean, and in fact, the second witness, who was the 911 call, it's not even clear that that was exculpatory, because he merely talks about having said in the 911 call that a friend of his was the victim of the assault, and then two guys said they were going to come back with guns, but it wasn't clear who those two people were, and if they were even involved in the assault. But with respect to Zhao, the total picture is totally at odds with what happened. And so you can actually envision how this would all play out. Because if anything, if he had put the witnesses on the stand and they had testified to what they had said in their reports, they would have been devastatingly impeached with the information that they later gave to the police, as well as by the nature of the wounds.
But isn't the whole purpose of wanting to talk to the witness themselves that what came through the police reports may not be the whole story or may not be accurately reported and so on and so forth? So it seems like, your premise sort of fails because that's the whole reason for the contact in the first place. And we don't know what speaking with Zhao or the 911 caller would have led to either. So judging materiality only based on what you say would have happened doesn't seem to be the right way to approach it.
I don't think that's the correct way to look at this, because you have to base probabilities, and it is ultimately a determination of probabilities on the information that's known at the time. And the information that's known at the time ultimately is not exculpatory. And you could actually make that argument about any police report, because they talk to a witness. That witness might actually say he didn't see anything, but you could say, well, if the defense attorney had gone to talk to that witness, maybe that witness would have actually inculpated the person. You can only make the analysis on the information that's available.
Well, and the information that was available was that two people said two people were involved.
Well, only one person said that two people were involved. The second person, it wasn't clear who those other two people were. The first person said he saw them attack with beer bottles. That isn't correct. And it's also the defense burden. It's not our burden to establish materiality. So the defense has to spell out how it actually is going to impact. He can't start speculating and said, well, if we talked to them, they would have changed their story. They would have provided a better story. That's not how it works. The defense has to spell out a reasonable alternative way if it would have panned out. He's in the realm of speculation if he's saying it's going to get any better than what it was in the reports. And what was in the reports wasn't good at all in the totality.
Thank you, counsel.
Thank you.
Counsel?
Thank you,
So
Judge.
why isn't it pure speculation, as he suggests?
Your Honor, the whole case would have been different had they been able to speak with these witnesses.
Yeah, but he argued that you abandoned your pursuit of any remedy. What did you do after Judge Silver's ruling?
Nothing, because he made the offer of the alternative. The people
Did
and the
you
court
offer
would
any
not
other
accept that.
Did you offer any other alternatives?
No.
Did you come back? Did you ask for a hearing?
It's not his burden to do any of those things.
That wasn't my question. Did you ask for a
No.
hearing? Okay. And you didn't offer any alternative?
That's right. Except the one that was rejected.
Do we know
one
from
very
this
reasonable
rec-
one that
I'm
was
sorry.
rejected.
Finish your answer.
Yeah, I'm sorry. What was the alternative? You said a reasonable one that was
I won't disclose this information to my client. You're worried about your witnesses? I won't tell them.
I see.
The protective order.
The protective order.
All right.
And I'll tell you why that he didn't take them up on their offer. And one, Judge Garcia pointed to one thing, which is, tainting the witnesses. But you don't want a law enforcement to go talking to your potential witnesses and finding incriminating evidence. Defense counsel, I'm sure, had that in his head. You don't want the DA doing your investigation. So that would be another reason not to accept that offer.
So, is there any evidence in this record, I don't recall seeing any, that the defense actually did go out and make an effort to try to find these people with the names?
It was impossible, Your Honor. They had Asian names that were the functional equivalent of Smith and Jones, and
a
the club was
diverse range
closed.
of names in this country, but so the fact that it's an Asian name in and of itself
No,
is
he
irrelevant.
proffered that they were very common Asian names, and there was nowhere to look for them because the club had closed. There was absolutely no possibility of doing an investigation other than getting that contact information.
These are also transliterated names, so,
Right, that's right. They
Zhang
were
and
phonetically
Zhang
rendered.
And Zhang, and you don't know exactly how
That's
it is, right?
So they could be wrong anyway?
I'm sorry?
Since they're phonetic, you mean they could be wrong anyway?
That's correct. But the contact information presumably would be right.
Yeah, but to say that their names were too hard for us to be able to find them seems to be, it's not a legal theory or a pronouncement, and I don't think this court should be making it. And it seems like a cultural limitation you're allowing of the world we live in to make a determination for you like that. That'd be the fairest way to put it, I think.
I don't think so, Your Honor. If their names were Smith and Jones, where would you look for them? In Brooklyn. There's just no way, you can't,
Well, the people didn't argue otherwise, correct?
sorry?
The people didn't argue otherwise.
No, that's right. They didn't argue that. They didn't argue that there was a particularized harm to any witness that was possible from this. If I may, I'd like to just state what I think the rule ought to be.
You may, sir.
The people must, I'm going to read this to get it right, at least upon request, disclose contact information for potentially material exculpatory witnesses, at least when the defense has no other means of investigation, unless the people can show at a hearing that doing so would put witnesses at a particularized risk of harm, in which case the least restrictive remedy, something like an order of protection, ought to be ordered.
Thank you, counsel.
And who has the burden to request that hearing, you're suggesting?
The people. They're the ones that want to avoid the obligation.
Okay, I just want to be clear.
Thank you, counsel.